Miller. Welcome to Lunch with Littman Krooks. This is an informal program we've been putting together on a weekly basis, Tuesdays at 12 o'clock, and they'll be every Tuesday at 12 o'clock going forward. Today, you've logged on because we're going to talk about some of the more recent updates in community or at-home Medicaid program and what to expect. Some of what we do know, some things have been clarified from Department of Health recently, and there's still some things that are a little unknown to the legal community. You do not have to share your video if you do not want to. This is an informal program, so I will not have a PowerPoint or anything of that nature, but if you do have questions, there is a chat bar at the bottom. You can click on the bottom and type chat and put in your questions. And at some point I will get to them and try to answer as many as I can. I'm hoping not to go more than a half hour, maybe 45 minutes. I know people are doing this on their lunch break and trying to get back to work or doing whatever they are doing. I do ask that if you have background noises or something, you do mute yourself. I know certain people I see are unmuted, but that's okay because I haven't heard from you, so we're good with that. I'm just allowing a little more time. I know people are still coming in, still waiting in the waiting room, and would like to give them the opportunity to hear the program in its entirety. If you would like a copy of this presentation afterwards, you can contact Kian Mama with our office. Her email is kmama@littmankrooks.com, K as in kite, M as in Mary, A as in Apple, M as in Mary, A as in Apple @littmankrooks.com, and she'd be happy to assist you in getting a recording of this program. Looks like we may have slowed down in the influx of people, so why don't we begin with kind of what's going on in the Medicaid world, especially for community Medicaid and at-home Medicaid. Again, if you have any questions, type them in the chat and I will try to answer them later on. As you may have heard, or anybody that's been following our website and our Zoom conferences, Medicaid in April had significant changes. As part of the budget program, the governor and the legislature got together and reworked the community Medicaid program, making it a little harder and a little more difficult for the clients to obtain community Medicaid benefits. What they've done is they have installed a 30-month look-back period. Prior to these changes, there was no look back for community Medicaid. But there was and still is a 5-year look back for nursing home Medicaid. And that is where Department of Social Services, HRA, or whatever your local municipal social services department is called, looks at the applicants, and if they're married, their spouses' financial records for the past 5 years to see if they've made any of what they called uncompensated transfers. These are transfers that were made not for a fair market value. Maybe they were a gift, maybe they were created a trust, an irrevocable trust or something of that nature, which could be considered an uncompensated transfer and would incur a penalty period. That penalty period is a period of time based upon a mathematical calculation done by Department of Social Services where Medicaid would not pay for one's nursing home care while they're in the nursing home, forcing the applicant to private pay for their nursing home care. Right now, in nursing home cases, Medicaid goes, or private pay is $15,000 to $20,000 a month for a nursing home, and it is less for community care, but it was something we always had to plan for and work with our clients when applying for nursing home Medicaid. Community Medicaid or at-home Medicaid, we never really had that problem because essentially you could transfer all of your assets today, and as long as you get under the limit, $15,750 for a single individual, and there's a sliding scale for a married couple. As long as we could get you under that asset limit, you met the medical requirements, we could apply for Medicaid, community Medicaid for you the very next month. However, with this new law, they are imparting a 30-month look back for community Medicaid. And so in this regard, Department of Social Services, or HRA, will look at the applicant and their spouses, if they're married, their financial records for 30 months prior to the application to determine if they made any uncompensated transfers, which would create a penalty period. And there was many unknowns and questions about this, and what we've recently learned from the Department of Health is that they are pushing back this look-back period to start January 1, 2020. The way the law was written in April, it was to start October 1, 2020, with the possibility of it being pushed back. It is now being pushed back to January 1, 2021. I'm sorry if I said January 1, 2020 earlier for any confusion, but it is being pushed back or adjourned to January 1, 2021. However, they will start the actual look-back period as of October 1, 2020. So if you apply for Community Medicaid benefits anytime after January 1, 2021, they will look back at any transfers you made starting October 1, 2020 going forward, which is kind of put people in a position when we're telling our clients, get your estate planning, your asset transfers done now before October 1 to protect and preserve those assets, because you can make transfers, you can do things with your assets now to protect and preserve them prior to October 1, which may create a penalty period if you do it after October 1, but if you do it before, it should not create a penalty period. But we don't want you just going out and giving your money away, because even when we do community Medicaid planning, we're always having in the back of our mind, what happens if I need nursing home Medicaid within the next 5 years? Well, we may need to give the money back, need to undo plans, or something, a combination of things to kind of get you back to square one to then do some type of crisis planning for nursing homes. So it's not recommended you do this on your own and you just start giving away money before October 1 to qualify for community Medicaid later on in the future, because if you do run into some type of crisis situation where you then need community Medicaid, you may need to undo that plans. So they're really, I mean, I'm looking at the date now, it's July 28th. We're really 2 months away from this imposition of this look back period for community Medicaid. So we really are urging our clients, if you've been on the fence, I don't know if I want to do this, I don't know what I'm doing, if I'm going to need community Medicaid or something of that nature in the future, you really have a couple months to get this done, and there's going to be crunch time as we get to the second half of September. So I'd say you have even less than 2 months to really get these plans in place to protect your assets. And when we do these plans and we protect your assets, we are always in the back of our head thinking, what if they need nursing home in the next 5 years? So we're not going to tell you just outright gift your assets to your children or something of that nature, because most of the time it doesn't make sense, and it's actually could put more damage to you than need be. The other thing with doing proper estate planning is we would preserve the step up in basis. And some people may not be aware, but where you have an appreciated property, and I'm just going to use the family home as an example. We have many clients that bought their family home, maybe $50,000 back in the 1960s. It's now worth several $100,000 or $1 million plus with the inflation. And so there is, it's an appreciated value. And if they were to sell that property, while there are some exemptions, if you're single, you get, I think, $250,000. Married couples get $500,000 of appreciated value that they don't have to pay capital gains tax on. But if you were to sell that property during your lifetime, there would be a possibility of you paying capital gains tax. And if you were to give that property to your children without doing a proper planning through some type of trust or life estate in the property, your children could be given a property that's worth a lot, but be giving them a lower basis of what you paid for that property. So when they turn around to sell it, they will have capital gains taxes. But if we do this planning properly to qualify you for Medicaid, but also preserve the value of your estates and protect your assets as best we can ensure that your children get the step up in basis upon your death, and so their value of the property is the value at the time of your death as opposed to the value when you purchased it. And so that's why we want to get these things done sooner rather than later, because there are these transfers that we can do before October 1 that would be a little more dicey come after October 1. But it is good to know that Medicaid is not going to install this penalty, this look back period until January 1, but they are going to look back come January 1 as to October 1. And like I said, it is a 30-month look back. They're going to start October 1 with the look back and graduate it or over time. So that way come April 1 of 2023, which is 30 months from October 1, they will have the full 30-month look back period. With that being said, I know we have some clients that are currently on Medicaid and they're saying, well, how is this going to affect me? If you're currently receiving community Medicaid benefits, it should not affect you. It should not affect you when you go to recertify. The only way it probably would affect you is if for some reason you were denied or got off Medicaid for some reason or another. Maybe you got better and no longer needed care, and then apply a couple of years from now or something of that nature. Then they would incur that 30-month look back period. But for people that are on Medicaid and continually staying on Medicaid, for community-based Medicaid, when you recertify, you do not have to worry about this 30-month look-back period. Then the next question is, okay, well, what if I make transfers after October 1 and it creates a penalty period? What do I do then? Well, first is you are kind of in luck in that Medicaid has a divisor that they use for creating this penalty period. In Westchester County, that divisor is $12,805 per month. New York City is $12,844 a month. And each region has their own divisor number. And this is the number that Medicaid says the average nursing home would cost in that area. And while we're saying, okay, but we're here for community Medicaid, what the Department of Social Service and Department of Health have said is we're going to use that same divisor that we use for nursing home Medicaid for community Medicaid. So it is helpful in that where sometimes a community Medicaid may only be $6,000 to $7,000 a month, you're at least getting that divisor of almost $13,000, $12,800 plus a month. So what Medicaid does is they will look at all of your transfers made in the last 30 months or in the last however many months back to October 1, 2020, look at any uncompensated gifts or transfers that you made, add them all up and come out with whatever that number is. And say that number is in Westchester $12,805. So you made $12,805 in gifts. They would divide that by the divisor 12,805 and incur you a 1-month penalty period where you would have to private pay for your care until Medicaid came in to cover those benefits. Which is helpful because that private pay should likely be less than $12,805 because community or at-home care costs significantly less than nursing home care. But then the other question we've had is, well, how do we know when the penalty period starts? And what we've discussed, and when I say we, I'm talking about the New York State Bar Association, the Elder Law Committee, Westchester County Bar, the different bar associations of attorneys and elder law practitioners through the state have been on different conference calls with the Department of Health and with our lobbyists in Albany, trying to figure out some of these unknowns and nuances to this new law. And they're saying the penalty period is likely going to start once somebody A, medically qualifies for the need for medical care, and B, financially qualifies. In other words, that their assets are below the set limit. Right now, for a single individual, those assets are $15,750 of available non-exempt assets. So once somebody financially qualifies, medically qualifies, and has submitted their application, then the penalty period should be able to start from from that point in time. Again, this is still a little gray area, and we're still trying to hammer down the specifics, which is why we tell you this, and we always recommend this is applying for Medicaid, especially now, is not something you really want to do on your own, because the laws are changing, because there are so many unknowns. You're going to need somebody to advocate on your behalf as to what the law is and why you qualify and the benefits you should receive. There's also a question we've had is people asking, what about transferring of my house? I'm in a community Medicaid. What if I don't transfer my house now, but wait until after October 1? And this is an area that there are many people on the position that, look, if you're not transferring the house to qualify for Medicaid, but maybe putting it into a revocable trust or an irrevocable trust, something of that nature for other purposes, you should still be able to qualify for Medicaid, and it shouldn't create a penalty period. Because this is a new area of law, there are going to be times where that's going to require extra work in fighting with Medicaid, Department of Health, going to fair issue hearings. So I really recommend, if we can, transfer before October 1 to save you the legal fees later on of fighting with Medicaid when they try to say, well, you transferred the house after October 1, and we turn around and say, well, it wasn't for Medicaid purposes or to qualify for Medicaid, but for some other purposes. And while I think there's great arguments to be made and be able to prevail on these arguments, it is going to cost you legal fees to fight with Medicaid in the future. So rather than putting a fight later on and spending more money later on, get these plans in place now to really protect and preserve your assets and not pay extraneous legal fees, which you may not need to do. And then you say, well, a lawyer doesn't want fees. No, I want you to be happy. I want your assets to be protected and go as smoothly as possible to get you or your loved ones the care that you need. Another question that has come up over time with these new laws is, well, what about pooled trusts? Right now, community Medicaid applicants are able to use pooled trusts to preserve their excess income. A single individual is allowed to have income of $875 plus a $20 set aside, so $895 a month. Everything over and above that gets paid to Medicaid or paid for their care unless they use a pooled income trust. And we've had many clients say, well, will you still be able to use that? And what we've learned is that yes, Medicaid is still going to allow individuals, including those individuals over 65 years of age, to use a pooled income trust. However, the funds that are used in the pooled income trust, and these are income that is excess over and above that you put to the pooled income trust, must be spent on the Medicaid recipients on them. So it's got to pay their bills, got to pay for their clothing or what have you, but it must be used and spent for the benefit of the Medicaid recipient. What we don't know is how often Medicaid is going to make us provide this proof that the money put into the pooled income trust has been used for Medicaid benefits, Medicaid recipients' benefit. I know people that use these pooled trusts to kind of accumulate and pay maybe their property taxes when they come due or something of that nature. We're still waiting for more clarification. Does this have to be reported every month? Does it have to be reported every 6 months, every year? And as we learn this information, we will be providing our clients and updating our website and our blogs with more of this clear information. But yes, you will still be able to use a pooled income trust. It's just unclear right now as to how often that has to be reported to Department of Social Services. Those are really the big issues coming down the pike with Medicaid. There are some real nuanced issues really more for the legal audience as to how to put these applications in, what arguments to make to Medicaid. But for the clients that are really looking to apply or may need to apply for community Medicaid now or in the near future, know that this 30-month look-back period, it starts October 1, 2020. but is pushed back to for applications filed on or after January 1, 2021. So once you put that application in, come the year 2021, they will be looking back at your assets starting October 1, 2020. We are still able to make those transfers and do the estate planning now under the current laws as they exist up until the end of September. After October 1, that planning will change a little, but I would much rather my client get these plans done in place under the current laws, which are extremely favorable to you, rather than after October 1, when we may have to fight with Medicaid later on down the road in a fair issue hearing for maybe transferring a house to a trust, saying that it's an exempt transfer, but still having to fight with them to prove why it is exempt. I'm going to look at some questions because I know we're coming up on the half hour, and I did not want to keep you too long today with regard to this. So if you do have questions, please put them in the message box or the chat box at the bottom and take a look, see if we have any questions to try and help clear up any unknowns to you. Is it current? I see one here. Currently, can you have both Medicare and Medicaid? Yes, you can. In fact, you're required to have both Medicare and Medicaid, provided you're of the age or of the ability to receive Medicare benefits. When you apply for Medicaid is a payer of last resort. And so in that regard, they require Medicare, any long-term care insurance, any health insurance, supplemental Medicare, Medigap, any of those to pay before Medicaid will come in and pay for your care. So yes, you are able to have both, and you are required to the extent you qualify for both to have both, because Medicaid is a payer of last resort. Is this retroactive to those already that have Medicaid waiver? As I mentioned earlier, this is not retroactive. It is for new applicants after technically January 1, 2021. They will look back to October 1, 2020. The only way it may possibly become retroactive is for those people, for whatever reason, are kicked off Medicaid and have to reapply for a new Medicaid. If we see that may be an issue, but we haven't even gotten to where they're applying this look back period, so we haven't dealt with this issue yet. It's something we're going to be looking into further in the future once Medicaid does start this look back period. Does that include transfer of property owned by New York resident in other states? Yes, when you apply for Medicaid, if you're a New York state resident but you have property outside of this state, when you transfer that property outside of New York state, that could affect the your Medicaid application. Because when you do apply for Medicaid, they want to know about all of your assets, all of your income, all of the property that you have, not just that in New York, and not just that in the US. Perhaps you own, I've had clients that own property in India or Italy or somewhere in all over the world. I've had different things, and you are attesting to these are my assets, and assets are not just what you own in New York, but own anywhere in this world. So yes, if you transfer property outside of, maybe you have a vacation house in Florida and you give it away to your child as opposed to selling it, that could become a problem when you apply for Medicaid, providing you do that after October 1 and you're seeking either community or nursing home. And as I said, nursing home has the 60-month or 5-year look-back period. Are deeds into trust able to be recorded now during COVID? What if the deed does not get recorded before October? I have been doing quite a few deeds lately, and my recording company has been recording them. My understanding is that the deed for deeds, and this isn't stock certificates for co-ops, but actual deeds are effective the day that the deed is signed. by the owner transferring it to their trust or to somebody else. Because often it takes a little while for the deed to get recorded, but the transfer is deemed effective once that deed is signed. It legally transfers the ownership of the property. Will this impact the use of long-term care policies that are part of the New York State Partnership Plus? The Partnership Plus program does allow for the protection of excess resources above what Medicaid allows, and sometimes even protection of all resources. And this should not affect the long-term care policies that are part of New York State Partnership Plus. This really looks at transfers that have been made within the last 30 months, beginning October 1, 2020 and going forward. What is the definition of community care? Community care is home health aides, home nurses, care that you receive at home, or if you happen to maybe in an assisted living facility that is not a nursing home, but an apartment or an assisted living facility, care that comes to you in the community. So that's what community care is. It's home care as opposed to nursing home care. Will Community Medicaid provide for 24-hour in-home care? This is getting harder and harder to obtain 24-hour care. With these new laws in place, they will be creating a task force to look at the care and care over what we believe is going to be 12 hours a day. They're going to have a task force review these individuals' care to see if it's needed, not needed, and what type of care is needed, be it 12 plus hours, 24, or even at live-in care, which technically is not 24 hours, but some people consider it 24 hours as live-in care, where somebody lives in with you and provides you the care over the course of the day or week. And so will community provide for 24-hour home care? That's going to be a case-by-case basis. When you apply for Community Medicaid, they will send somebody out to evaluate you. My understanding is they're doing some of these evaluations right now via teleconference or video conference because of the COVID and people not wanting to allow others into their house during this time. So 24-hour care may be available, but it is getting harder and harder and harder to obtain that length of care. And quite often we'll work with geriatric care managers to try and assist and help the clients and put them in best favorable light and position to advocate for their needs as to why they need further care, and also work with their doctors as to why an individual may need more care than 8 to 12 hours a day. But yes, it is possibly available, but it's going to be harder to get. And the reason these laws were put in place is because there was such a huge deficit in the budget, over $6 billion before the start of COVID, and they say at least $4 billion, if not more, was attributed to Medicaid costs. I have a partner of 8 years on Community Medicaid, want to get married. How would that affect my financial picture? That's a really personal question, and perhaps we set up a consultation to discuss that, because once you are married, you are required legally to provide for your spouse. And I don't know what your personal finances are or your spouse's finances. So something like that is more in personal nature, and we would be glad to set up a consultation with you to discuss how it may affect you and or your partner going forward. On average, this is a good one. How long does it take to transfer a home to an irrevocable trust, and deed, etc.? And I'm going to deal with homes as opposed to co-ops, because co-ops are a beast in themselves. And I say beast because you're dealing with the co-op board, you're dealing with the co-op management company, you're dealing with the co-op's attorneys, and we try to push the co-ops as quick as possible, but I've found some of these co-op attorneys dragging their feet, taking several months to do. But however, if you have a good rapport with your co-op manager, maybe we could get them done a little quicker. Transfers to an irrevocable trust and a deed. Once we get the trust drafted, we have you come in, sign the trust and the deed that day. I'd say it takes us maybe a week to two to get some of these trusts drafted. Once we discuss with you and figure out what your true goal is, who you want to be responsible for being the trustee of the trust, and kind of hammer out some of the fine details. Get these drafted in a couple weeks, and the deeds change rather quickly. So there is still time to do these documents before October 1. But as we get closer and closer to October 1, there's going to be a crunch, and I could foresee more and more clients coming in. And when you get more clients, you get you get kind of a little backlog. So that's why I'm encouraging people to get these documents done sooner rather than later. Can family members be paid to care for Medicaid recipients? There is a program called the CDPAP, the Consumer Directed, and I'm drawing a blank as to what the PAP means, there is a program where you can have your family members be paid by Medicaid to provide care for you. Part of this, the new regulations, is Medicaid is no longer going to be advertising this program. But we as elder law attorneys do know of this program and can help you work through that, where a loved one other than your spouse can be paid by a company that has a contract with Medicaid, Department of Health, Department of Social Services, to be the intermediary to pay your loved ones to provide care for you. Again, similar to, it's still a community Medicaid hybrid, in that you still have to qualify for community Medicaid. They still have to come in and evaluate you and tell you how many hours you are entitled to. But yes, you can still have your loved one be paid by Medicaid. Okay, and this is, I think the last question that I see is, what is the advantage of becoming eligible for Medicaid? Would you wait until you have significant illness? How can you anticipate that you will need Medicaid 30 months in advance? You cannot apply for Medicaid until you actually need Medicaid, until you actually qualify for Medicaid. So qualifying, there's the financial aspect that you financially qualify, but you also medically need to qualify. You need the at-home care or the nursing home care. So you want to kind of put yourself in a place where when you need those medical needs, you're able to become financially eligible as well for Medicaid. And I know this person asks, well, how do I know if I'm going to need Medicaid in the next 30 months or nursing? It's not part of this question, but nursing home in the next 5 years. And some of that we don't know. And so doing these type of estate planning, asset protection planning, is akin to almost an insurance policy. We don't know when we're going to die, but we have life insurance. Well, we don't know when we're going to need home care or nursing home care, but if we put our plans in place now, when the need comes, we've been proactive and able to preserve as many assets as we can to qualify you for Medicaid. When you do the proactive planning, you are able to preserve generally more than when you do what we call the crisis planning, when you're like, oh no, mom or dad had a fall, they need care, or they need to be in a nursing home. And now we're under that guideline, this guise of, okay, well, there's a penalty period for transfers, so we're not able to preserve everything or as much of everything if we were, had we done it proactive before the 30-month look back or before the 5-year look back period. So no, we cannot predict the future. I always tell my clients, if I had a crystal ball, I'd be in a different business. I don't have a crystal ball, so I can only do my best is to proactively set your estate plans in place, so that way when the need does arise, you are qualified or able to qualify for Medicaid benefits. If you have long-term care insurance and assets much higher than $15,000, Medicaid is not appropriate for you. Not necessarily. Long-term care insurance sometimes does not cover everything. I've had many people come in with long-term care insurance policies that'll maybe pay $250 to $300 a day when the cost of care their type of care had been $500, $600 a day. So they still needed to come up with some extra revenue to pay for their care, which is Medicaid. And while you may have assets much higher than $15,000, we'd have to look at those assets. There are exempt assets such as IRAs, 401ks, where if they're in a payout status, they're not looking at the principal, but they're just looking at the income. There are exempt assets such as the house, provided it meets under the equity limits set by Medicaid. There are assets which put you over $15,000, which could create an issue, but we're able to handle them, deal with them, and do some type of planning to allow you to preserve some of those assets if you're doing crisis, and perhaps all of those assets if we're doing, or nearly all of those assets if we're doing a proactive plan. But we would need to look, and each client is different, we need to look at your individual assets. But just because you have long-term care insurance and assets higher than $15,000, do not think that Medicaid is not appropriate for you. I've had clients with 7 figures of assets, and we're able to still get them to be Medicaid eligible when need be. So no, Medicaid is still a viable option, sometimes the only option for people that still have more than $15,000 of assets in long-term care insurance. Our IRAs, 401ks accounts part of assets considered by Medicaid. If they are in payout status, you're receiving your RMDs, Medicaid does not look at those type of accounts with regards to the principal. They will look at the income coming in and count that as part of your income. And is there currently any look-back period to become eligible for Community Medicaid? As I said, right now, there is no look-back period. That look-back period starts October 1, but they're not going to actually start looking at those assets until January 1 of 2020. When you say RRA income is counted, does that mean RMD is counted? Yes, I think I just answered that. The RMD is counted as income. And I believe that's all the questions I have. I ran you a little later than I wanted to. I will be posting an article later this week, kind of detailing some of these changes that have gone through. I'll be posting that to our website. We are going to be hosting these Lunch with Littman Krooks programs on a weekly basis, and they're going to rotate. I believe the next one is August 4th. Joel Crooks from our office is going to be doing a program, Am I Too Young to Have an Estate Plan? And then every Tuesday thereafter at 12 o'clock, we're going to be doing programs. I'm just looking at my calendar now. August 11th, we have What You Need to Know When a Loved One Dies. August 18th is going to be pandemic planning, a checklist for preparing students for the new and uncertain school year. August 25th, we're going to talk about special education and partial hearings. September 1, we're going to be talking about the basics of Article 81 guardianship in New York. And if there are programs that you're interested in looking forward to or would like more interest, please send us an email. Let us know. We'll, if we get a good enough response, people inquiring about a certain topic, we'd be glad to put on a program and educate you, because I'm sure there's many others like you that have very similar questions. I know there's a lot going on right now with the changes in Medicaid, with the COVID pandemic, with back to school, and what is back to school going to look like. And we're in a world that we haven't seen before, and so we're trying our best to keep you educated. And while one topic may not be good for you or particular to you, going forward, we're trying to reach all of our audience. And maybe the back to school doesn't work for you, but you have grandchildren, and so you could let your children know, hey, you may be interested in this program for back to school. We are going to continually keep you updated. We're going to continue these Lunch with Littman Krooks. We're going to continue to update our blogs and let you know of the changes in the law. And I thank you all for taking the time to have lunch with me today. And if you have any questions, shoot us an email. If you want more particular questions with regard to your particular situations, I'd be glad to set up a consultation with you and discuss your particular needs. If there are any other questions after we hang up or after we log off, shoot us an email and we will try to respond to them accordingly. Thank you all again for coming. Have a safe week. Enjoy the heat wave that we're having. I guess it's better than the snow. And we're always here to answer your questions. Thank you all and have a good day.